with BQ Prime, and this is the fine print. It's been a few days since the draft data protection bill was put in the public domain. So hopefully businesses and their advisors would have had chance to deliberate on how businesses should prepare for what's coming their way. Today, Khaitan Supratim Chakraborty joins me on how companies should prepare for obligations that are imposed on this proposed bill. Supratim, welcome to the Fine Print, and thank you for taking out the time to speak with us. Before we come to the specifics, can you articulate for me some of the queries or, let's say, initial responses that have come or have been shared with you by your clients?
Right. I think, of course, the foremost one is what should we do now? And also that, if we are to give our submissions, what are the top 5? Or top 10, maybe points that we must put forth. There are some low-hanging fruits, which, of course, I've been telling businesses for very long, like reframing, re-articulating notices and consents, okay, in an itemized format, in an easy to, read document, etc. I think that I have kind of re-emphasized on. The time has come now. Anyways, we should do it. Otherwise, what I have emphasized on is probably start looking at translating the notices and consent in all the 22 languages, because if you see the recently amended intermediary rules, it also kind of pushes you to the direction that you need to have the notice and consent provided, or at the option of the user provided. And therefore, it's about time, I guess, maybe we'll have to work on it and there'll be good business for this industry.
Okay, so Pritam, let's look at the specifics now. As any good law should, this bill too, or when it becomes law, will apply prospectively. But the question arises, what happens to the data that I've already shared with my bank, that I've already shared, let's say, with my telecom provider, I've already shared with a restaurant. So how will companies now process this old data? And will there need to be specific steps that will need to be taken vis-a-vis data that users have already shared with companies big or small?
No, very good question, Paisuni. And this is a question which many companies are asking and grappling with. I think a balanced approach has been taken. In relation to old data, what we understand is you will have to give a notice. Okay, notice is, I think, quite plain vanilla, because it needs to contain the kinds of personal data which is involved and the purpose of usage. We are all aware internationally, purpose limitation is a very big thing, and therefore that purpose aspect needs to be told. But there is no requirement for you to go and take re-consent. I think this is a good move, at least from a business perspective, because otherwise this would have been catastrophic. Okay, for all the data to go back to data subjects and ask for consent could have been quite tedious.
So break it down for me. Let's say, will I now get intimations from, let's say, a service provider, whether it is, a hotel I had shared my Aadhaar with, because all of us share some sort of identification proof when we sort of check in, or let's say my KYC details. Now, will I get, as a user, start getting emails, or let's say the companies will need to send specific emails that, hey, look, this data of yours is there with us, which was used for XYZ purposes, because some of those purposes would have sort of lived their life. So can you break it down for me, that how will this communication need to go out from the businesses or the companies?
Right. So I think two aspects here. Okay, one is notice is a given. Okay, it is given in the law and you'll have to send it out. You have to mention those two elements, like I mentioned. Thankfully, there is not too much to mention in that notice. But if you are saying that the purpose has changed, then you will also trigger the consent requirement. Then, if you observe, the way it is written, you'll have to go back and again ask for consent. And, there also, I think the consent elements are also fairly simple. Same two elements have to be provided, the kinds of data that you're collecting and the purpose. These two are to be mandatorily provided.
Okay, and will the language need to say that we had this data, but now that the purpose is over, you have the option, because there is a right with the user now that I can ask for my data to be deleted if the legal or the business purpose has been served. So now will businesses need to give that option as well to users?
The curation of the language is, of course, up to the businesses. But yes, it would be prudent to write it in that manner that it was always with us. And if you have seen this in GDPR times also, you would have received tons of those emails which stated, this data was with us, and please provide consent. So that language, I think, is fairly standard by now.
Right. Let me come to a little bit on this consent, and there is also the concept of deemed consent here. So consent is that, we're going to use your data for XYZ purposes. You're getting, let's say, a new SIM, or let's say you're, getting an airline ticket. So for that, you have, shared the data with the service provider. There's also a concept of deemed consent. Can you sort of, while there, the bill gives an example of a restaurant booking, that would legitimately need my name and number to contact me in case I show up late, or for any other reason that they might be canceling my booking, they will need my details with them. So that sort of seems a very obvious example of deemed consent. How do you think this deemed consent will practically play out from large businesses who do a lot of this thing on a daily basis in terms of providing of services, and even smaller purposes which have a very targeted use in terms of, let's say, booking a rental car, or let's say the restaurant example that the bill itself provides?
Right. A very good question again. Let me tell you, internationally, other grounds of processing have been very prominently known. Okay. Aside from consent is just one of the grounds on which you can process data. There can be other grounds also. It's not unheard of, it is not unknown, and it is not new. It is just how perhaps it has been packaged now. Okay. Now, let me come to specific examples so that it is easily understandable. And I'm telling you from my real life examples, matters that I've handled myself. Employee investigation. Okay. Classic example. If you read the Sensitive Personal Data Rules, Information Technology Act, and follow it litera legis, in a bad day where you're having an employee investigation, unless some consent has been taken before, etc., you will actually have to go and ask for consent of that individual to say that I'm going to check your laptop. Okay. Now that in a bad day is quite impossible. And therefore, you needed an avenue that minus consent, I have a genuine requirement to look into the system and process that personal data. Okay. So that avenue, just an example. Okay. Another example, which we have faced with a GDPR type issue, exchange of greeting cards, visiting cards between two people at a conference, and the person comes back and sends an email. Right now, this is something which is expected, that you exchange cards so that the person can go back and contact you. This is one. Third example, which will be very relevant for you, I guess, going forward, M&A, mergers and acquisitions, when you see tons of data moves from entity A to entity B. Now, if you're expecting that it needs to go down to the granular level of asking each individual customer, to have given consent to this particular M&A activity, it could be problematic. Of course, it's couched under, I think, the head public purpose and also, but point is that there are many other avenues which requires you to process data minus consent, and it is absolutely fine to do so. So this is how I believe people will start understanding the importance of it, and it will be useful.
But the bill doesn't sort of in so many words articulate that that these are the deemed consent scenarios that can play out, and it's sort of also unreasonable to expect the lawmakers to lay down every possible sort of use case where deemed consent will work. So I'm just trying to understand that, given that the language is broad, and given that the language or the bill doesn't or cannot realistically specify, how will, let's say, you distinguish in practical terms where you need to take consent and where deemed consent is sufficient?
Right. I think we should follow the spirit of the law. A. B. Understand that we should do things rightly as per the intent of the legislation. Okay. And I'm telling you, you can write enough, but probably that will not be sufficient. There'll be players who will try to have a workaround. Okay. Let me give you an example. When GDPR struck us, you saw like a lot of people sent consent related emails to us. Okay. Some players observed that once they realized that perhaps their database of 2 lakh was there, and they received consent from less than 2,000, they immediately change their mode to saying that this is legitimate interest for me to, actually send you the communication. Now, there will be people like that, right? But if you truly see the intent of the legislation, I think we should stick to that. We just stick to the spirit. The way the legislation has been crafted it's a lucid, light touch one, which is trying to give liberty to the industry. Now, I think the industry should reciprocate.
True, but I mean, like you said, there's going to be sort of, let's say, some players who would want to take advantage of this light touch regulation. Is there enough, or rather, is because it's not very detailed, the data protection board that is contemplated under the bill, should that get now the powers to see or examine and maybe pick up some examples playing out in the market as this law matures, to then say that, look, in these cases, an active consent should have been taken, and you can't sort of bring this activity under deemed consent umbrella.
No, absolutely. I think rules should further specify things, and this will also perhaps mature with precedents. Okay, because this is a principles-based legislation which you see largely. Okay, so of course, as you see more precedents coming through, I think this will mature further, and people will understand the real intent.
Okay. In sort of one last question on it. Today, if let's say as a company or a business, I have 10, let's say, data sets, what should be the criteria that I should apply to say that, hey, look, for these purposes, I need to sort of get consent, or, now send a notice for old data, or this is legitimate business purpose, so I should, just go ahead with a deemed consent, let's say, understanding. Are there is there a blue line or a bright line test that companies can apply?
No, I think today there is no bright line test, but I think, like I was mentioning, there are very good examples, decisions from foreign jurisdictions, which we can adopt and understand how it could work out. I'll give you a simple one, right? You have provided your service, you have sent an email to asking the service recipient to rate you. Now, that is legitimate interest. Okay. So, these are examples, probably will mature, like you mentioned, as we go ahead. But these are things which we can pick up and implement and imbibe in our corporate culture, as examples that we should follow.
All right. Okay. I'll move to the next broad sort of topic that, I'd like your thoughts on, and that's to do with exemptions. So now a lot has been said about state exemptions and state agencies, getting exemptions to the wide scope that the government has or the language proposes, and sort of other purposes, let's say for prosecution, investigation. But there is another sort of, clause in the bill which says that from the private sort of sector, there could be data fiduciaries that the government can exempt from some of the obligations that are there in the bill. How are you reading this exemption, and to what situations, to your mind, companies or private parties can be exempt from the rigors of the law?
No, I think we all are hearing the intent would have been, say, to exempt early stage startups. Okay, some categories of MSMEs where we don't want to burden them with that kind of procedural compliance burdens. We have been having a bull run as far as our startup ecosystem is concerned. Every other day there was a unicorn. So therefore, I think the intent also from the government side is to see that can we in some way protect that ecosystem and see that we do not overburden them. Okay. Here, my two bits would be that, when you look at data privacy protection legislation, it is not only about the size of the organization, it is also the criticality of the data that they are handling. I've had situations where there is a small startup in India which is handling, say, mental health data of children. And there's a set of 4 people who are sitting and doing that work. Now, it does not matter what the size of that organization is. So I think that exemption, when it is given, it should be very gauged and judicious.
Okay. What's in there for the outsourcing industry? Are you seeing, let's say, any exemption coming their way? Because if I understand correctly, in terms of who it applies to, it's the processing of data of Indian residents, right? So we have a large foreign, data processing industry back home. What happens to data of non-resident or other foreign nationals?
Yeah, no, I think the way I'm reading the exemption that has been provided to the outsourcing industry is that if it is a data of foreign nationals, which is getting processed in India by an Indian entity, which has an arrangement with a foreign entity for the processing, they largely get all the exemptions, minus the one on data breach related, security related aspect. Okay, that security needs to be maintained. I think we can take a cue. I was there personally present actually when Justice Sri Krishna committee was having a meeting. I guess this was in Hyderabad, and this point was picked up that the outsourcing industry should be exempted. So what he said is that I agree with that point. Okay, and the place where you're housing that data, probably I should not have an outreach there, but I need to ensure that the lock and key and the guard outside is there. So I would protect it from a breach perspective. Okay, but because probably a lot of those data would already be guided by foreign laws, maybe stricter laws and more mature laws. So therefore, there is no requirement to put the rigor of our law again on top of that. I think that's a welcome move actually.
Okay, all right. There's also a fresh concept, if I can add, of consent managers. How do you see this sort of play out? Because are you hoping that now we'll have a cottage industry of consent manager service providers coming up? Because the bill defines it to say that, a consent manager is a data fiduciary, which enables a data principal to give, manage, review, and withdraw her consent through an accessible, transparent, and interoperable platform. How do you see this playing out?
Right. Firstly, I must say that when I read the bill, I also had a thought that a number of new businesses and industries will flourish. Okay, if this sees the light of the day, the way it is drafted, I think it's a good concept because we are all aware that we are having consent fatigue. Okay, none of us really read many of the things that are written in these terms and conditions and privacy policy and things like those. So why not have this situation where you give, say, your power of attorney to this entity? I'm just talking in a very crude sense, stating that I am okay with A, B, C, D, but not okay with X, Y, Z, and that is what they implement as a service. Okay, so you are kind of certain that it, whenever whichever app or whichever website you've given consent to, it is not beyond your broad principles that you have set out. I think in the previous versions of the bill there were some other thought process. If you remember, I think there was a concept called data trust score, right? Where we all understood that, consent, if we only rely on consent, probably it is not good. Let us have something additional to that. And we thought, just like your financial instruments have some rating, why not put a rating there where a layman can understand, okay, I can trust this guy. Okay, I can trust this business. So, that is not there right now. But I think consent manager is a good move. It's a novel one. I don't know if there are any sort of real precedents globally, but it will be a good journey for us, I think.
So I'm just trying to understand, let's say there is a restaurant called, let's say a Domino's, for instance, for example, right? Now, there is a XYZ private limited company, which is now providing this consent manager services. So every time, let's say Domino's has to talk to a user in terms of, hey, look, where do you live? Where do you sort of want this delivery to be? Or feedback, does it go via consent manager, or for what specific person, or at what stage does a consent manager sort of, come in? And is it going to be a three-way relationship for every communication? How do you see this play out?
Oh, it's too nascent a stage, and I'm just crystal ball gazing at this moment. But the way I'm looking at it is probably the initial stage would be the most critical one, where you're signing up to something, and where you actually accept all your terms and conditions, privacy policy, and everything. That is perhaps a stage where the consent manager could play a more critical key role, and if there is any update to that in future. But in between, whatever happens, I guess there's very little of consent, so to say, as far as personal information is concerned. Probably, that area they will not have a role to play.
Okay, all right. Final question then, Supratim. There are significant obligations for significant data fiduciaries, and of course that will get defined in the rules as the bill sort of, tells us based on, the volume of data, the sensitivity, or anything that, can impact the electoral sort of, can have electoral implications. So they have listed some 5-6 criteria based on which a company or an entity who's collecting or processing data will get categorized as significant data fiduciary. Now, these SDFs will have to then conduct impact assessment. They'll have to have audit. Again, do you have parallels of how this functions? And today, as a company who could potentially be categorized as an SDF, what do I need to start doing?
Right. I think another important point to add to your list was a resident data protection officer.
Yes. Yes.
So anyway, so I think DPIA, like impact assessment, I think is now kind of prevalent in some of the jurisdictions. We will probably have to take a leaf from there and learn. Okay, this is not very common, and of course, I'm sure that many of these industry players who are in the space of such service or similar service providers will ramp up soon to now start doing DPIA related activities. But yes, it's a novel one for India. And I think the only way to go ahead in a proper manner would be to learn from jurisdictions.
Anticipate when they say audit, I mean, are you again seeing existing sort of players ramping up this capability to become data auditors, or that's a new skill set that the market will need to prepare for?
No, I think it will be an additional skill set. Okay, I'm already observing as soon as search in started tightening its grip, you would have observed in the market that the newer players who are there forever are ramping up their skill sets, their presence in the country to provide cybersecurity related services and associated services also. Okay. So yes, this will require some additional skill sets. The existing ones alone will not help. But yes, you could see a proliferation in this front as well.
Okay. Supratim, last word on, the board's powers, again, contemplated the Data Protection Board to impose penalties. And I'm guessing that will be one of the item list in terms of feedback that industry will sort of present or submit to the government through advisors like yourselves. What have you heard from companies on that front? And also, I remember in the initial days when the Competition Commission of India had set up, the way every regulator, decides to make its mark is by imposing these penalties, huge penalties, headline-grabbing penalties. Do you anticipate that to play out in this data protection space as well?
The very interesting question, Paisuni, and actually at Khaitan & Co, we are running a poll right now on this specific question on LinkedIn, that what do you think? These huge penalties are a deterrent? Answer is yes. No, yes, but we should add compensation. Yes, but we should have criminal penalties. And let's see, it is open for a week, I think. Coming back to your question, yes, there is already quite a bit of hue and cry on the number that people are observing. Many think that there should have been also a percentage of turnover, etc., which should have been sort of put forth. But I think because they have also given the guiding criteria, basis which we will reach that number, I think it's still a balanced approach. It is not that every item will hit a 250 or a 500 crore mark.
I think breach is at the highest level of
highest. And that's why I was thinking that cybersecurity industry, I'm sure, will be now quite in demand, because if that's the number, I think that's the first thing that companies would try to guard against.
All right, and maybe rightly so. Supratim, many thanks for joining us here on the Fineprint and taking us through the initial prep that the companies might start, if not implementing, thinking about by the time that this law becomes, comes into implementation. They shouldn't be sort of waking up one morning. Thank you for joining us here on the Fineprint, and thank you so much for watching.
Thank you, Paisuni. It's always a pleasure speaking with you. And thank you.